This is Occupy Maine TV on Portland's Community Television Network.
On November 27, 2011, dozens of protesters marched from Capitol Park to the governor's residence to protest the order to end the encampment in Capitol Park. When they arrived at the Blaine House, they found the gate unlocked and entered the grounds in order to exercise their rights to free speech, peaceable assembly, and to redress their grievances to their government. Eventually, Capitol Police were joined by State Police, Augusta Police, and even 2 Maine game wardens. All of the protesters left the grounds when directed by law enforcement officers. However, 9 of them refused and stood their ground. When advised to leave or be arrested, they turned around and placed their hands behind their backs, waiting to be handcuffed. All were booked and later released to await trial. Justice Nancy Mills presided over the trial. Assistant District Attorney James Mitchell brought charges of criminal trespass against Lisa Burke, Kim Cormier, Patsy Messier, Jenny Gray, and David Page. Mitchell agreed they had the right to free speech and peaceable assembly, but not on the grounds of the governor's residence. Defense attorney Phillip Worden argued that the Blaine House was part of the Capitol complex and therefore a legitimate place to protest. He based his argument on the First Amendment of the Constitution, which each of the defendants believed gave them the right and the privilege to bring their grievances directly to the governor, the head of the state of Maine.
Madam Floor Lady, ladies and gentlemen of the jury, question before you, and it is asked individually for the 5 defendants. Did the defendants, knowing they were not licensed or privileged to do so, remain on the grounds of the Blaine House in defiance of a lawful order to leave? This is a criminal trespass case.
I want to thank you for your attention. I know how serious it is to be a juror, and the most we can ask for is for you to actually listen to the evidence and listen to the arguments and make up your own independent minds. And we really appreciate the fact that you've been doing that, and we know that this has been a long day for you, and you probably have better things to do. But it's nice to see, that there are Americans who are willing to serve as jurors for the very important right of deciding the guilt or innocence of people who are charged with criminal offenses. And I know that you're going to follow the judge's instructions and consider each defendant individually and say, with this defendant, has the state proved each of the elements of the crime of criminal trespass? And if you have a reasonable doubt on even a single element for a single defendant, your job is to return a verdict of not guilty. Now, it is true that most of these defendants work together, and there's a lot of common facts to all the defendants. But that's not absolutely true, and I just want to point out some specific things right at the beginning. First of all, as the judge mentioned to you, Lisa Burke elected not to testify. That's her absolute constitutional right. You won't hold that against her. What you do when you come to decide with her is she elected to put the state to its proof on all the evidence he put up there on that stand. What was there about Lisa Burke that proved that she knew she wasn't licensed or privileged to be there? And you can decide that independently, no matter what you may think about the other defendants and the fact that they testified. With David Page, he testified that he never heard an order to leave or was given an opportunity to leave. You heard testimony from a trooper to the opposite of that. That raises a credibility issue. And the real issue there is, does it raise in your mind a reasonable doubt about whether David Page was actually personally communicated an order to leave? That's different than the other defendants. And each defendant is entitled to be judged on their own merits or lack of merits. And I know that you'll do that, and I appreciate the fact that you'll do that. There are some other issues that kind of run across the board that haven't played a central role in this trial, but they are nonetheless elements of criminal trespass. For instance, if you look at your jury instructions on page 3, one of the elements of criminal trespass is that it be an authorized person who communicates the order. And you'll see right there is a sentence saying an authorized person can be any person, including a police officer, who is authorized by the owner of the property to order others to leave the property. Sure, there was evidence here that police officers ordered these people to leave, but did the state introduce any evidence at all about who authorized them? Did the governor call up and say, hey, these protesters are bothering us, can you go ask them to leave? Did anybody, was there any testimony anywhere in this trial that an owner of property authorized these police officers to go to that site and order these people to leave? I suggest to you there isn't any. On that basis alone, you could acquit all of them. But I don't want to just sidetrack on these smaller issues, because as I suggested to you at the beginning of the trial, there are much more important issues that arise in this case, even if this isn't the most serious criminal charge that there has ever been pressed. That is, it's part of this case about what the limits are of our citizens' rights of free speech. As you'll see from the instructions, free speech, protected free speech, no matter how unpopular, is not illegal. If these defendants were engaged in protected free speech, then they had a license of privilege given to them by the Constitution to do what they were doing. The issue is, was this protected free speech or not? On the evidence before you, there can be no doubt at all that on the first test of that, of whether they were engaged in speech, is undeniable. This was a protest, and nobody has ever denied anything about whether it was a protest. The issue comes down to the forum where the protest took place, the Blaine House. Mr. Mitchell has suggested to you that I argue that the Blaine House and the park are one and the same. But you heard the evidence. You heard the witnesses. Wasn't the issue not whether the park and the Blaine House are the same, but whether there was an area called the Capitol Area, and that in the entire Capitol Area, you could protest if you had a permit. And then we specifically asked, was there any distinction there in terms of the Capitol Area between the Blaine House and the Capitol Park? In your jury instructions, it's quite clear that the government can make what we call reasonable time, place, and manner restrictions. In other words, the government could say, here's a legitimate place for you to protest, here maybe not. But the question in this trial is, did the government do that? Did the state come forward with any evidence to convince you beyond a reasonable doubt that the government has elected to decide that this part of the Capitol Area is off limits? In fact, if the permit requirements apply to the entire Capitol Area, then it's just the opposite. But it wasn't our burden to prove to you. It's his burden to prove to you that they weren't licensed or privileged to be there. What other evidence was there? Were there the no trespassing signs? Were there the keep out? You're not allowed to protest here, but you are allowed to protest over in the park? Was there any evidence along that line? I asked you to listen for that, and I suggest to you that there wasn't. But even more fundamentally, we're talking about the right to petition for redress of grievances. Mr. Mitchell argued that they could petition for redress of grievances down in the park. Doesn't it make sense that if we're going to adopt a Constitution that says that we have a right to petition for redress of grievances, that allows people in a protest to at least march to the governor's mansion? We're not talking about breaking in their door or going inside the building, but to take their protest right to the door of the governor's mansion. And isn't that exactly what they were doing? I suggest to you that if you agree with that, then you not only have a reasonable doubt about whether he's proved to you that they are not licensed or privileged to be there, you're actually at the verge of concluding that they did have a legal right to be there. And it's not necessary for us to do that. All that's necessary is that there be a reasonable doubt about whether they were licensed or privileged to be there. But I want to suggest to you that this case may be even much, much simpler. Because while it's true that an essential element of criminal trespass is that the defendants not be licensed or privileged to do what they did, so that if you find that they were engaged in legitimate protest for redress of grievances, then you should find them not guilty. But that is not the only element here of criminal trespass. That's not all he has to prove to you beyond a reasonable doubt. For there is also an element of criminal trespass that he must prove beyond a reasonable doubt that they were not only not engaged in legal protest activity, but at the time they were doing it, they knew that they weren't engaged in legal protest activity. He must convince you beyond a reasonable doubt that they knew what they were doing was illegal. In your jury instructions, it says very specifically, the defendant must know subjectively that he or she was not licensed or privileged to remain in the place. Subjective knowledge means that the person must actually know it. If you have a reasonable doubt about that, you must acquit these defendants. Now look at the next paragraph, where it says, in determining whether the required mental state for a defendant has been proved beyond a reasonable doubt, you should consider any evidence of ignorance or mistake as to the facts or the law. Evidence of ignorance or mistake as to the facts or the law may raise a reasonable doubt as to the existence of a required culpable state of mind. Now, what is the required culpable state of mind that we're talking about? The required culpable state of mind that he must prove is that they knew that they didn't have a right to do what they were doing. And in deciding whether they knew it, you can consider whether they were mistaken about the law. In other words, even if you were to accept his argument that they didn't have a right to be there, but you conclude that they sincerely believed, but mistakenly so, that they had a constitutional right to be there, that can raise a reasonable doubt in your mind about whether they knew what they were doing was wrong. And if you have that doubt, you must acquit these defendants. Consider the evidence. It's quite clear that the police gave them an opportunity to leave. There was testimony that they were polite, considerate. Even testimony that when the police came, they voluntarily turned around, put their hands behind their backs. And the state makes the argument to you that because they knew there was a risk that they would be arrested, that indicates they had a consciousness of guilt and knew they were wrong. I suggest to you the more logical inference is just the opposite. Doesn't it suggest to you that when they had every ability to leave and didn't do so, that this wasn't a case of the police chasing after and catching a criminal who knew had criminal intent and that they were wrong? Rather, just the opposite. Doesn't it suggest to you that these defendants believed in what they were doing? That they were bringing their protest to the governor's mansion because they believed that they had a constitutional right to do so. And don't you remember that I don't even have to convince you of that. He's got to prove to you that the opposite is true, that they knew they had no right to do it, which means that he's given you evidence that creates in your heads a conscientious belief that it's almost certainly true that these defendants weren't sincere, that they knew they had no right to do it and did it anyway. And I suggest to you, on this evidence, you should find these defendants, each and every one of them, not guilty. Thank you.
The trial ended with a hung jury. 4 of the jurors sided with the defendants, believing they had a First Amendment right to bring their grievances to the governor and therefore a right to be on the grounds of the Blaine House. It was in the eyes of the defendants and their supporters a major victory for free speech, the right to peaceable assembly, and to bring their grievances to the government. I'm here outside the Kennebec County Courthouse with attorney Phillip Worden. Phil, tell me about the verdict, the final verdict, and what your thoughts are on the significance.
It was a hung jury, which means that there was no verdict at all. The defendants remain presumed innocent. It was clear to us that a significant part of the jury understood our argument that this was a First Amendment case and that they were engaged in lawful protest, and those jurors obviously held out on that basis.
Do you have any idea how many? Was it just 1, 2, or more?
The last we heard was the split was 8-4.
8-4. To me, this seems very significant. What do you think? I mean, a trial of this sort and the state loses it, really. The state usually views these as very easy cases. They're civil disobedience cases. Everything's done out in the open. It's not a matter of having to prove too much because the defendants usually get up and admit what they did, which most of these defendants did, that they were engaged in protest at the governor's mansion. Only they said they had a right to do it, and the state said they didn't have a right to do it, and the jury got hung on that issue. And so you think it was the First Amendment rights that those 4 there were arguing trumped some local law and jurisdiction of civil trespass or civil disobedience or criminal trespass?
Right. There was never any issue about whether the First Amendment trumps criminal trespass because all sides agreed that it did. What the disagreement was is whether the First Amendment applied at the governor's mansion, whether that was what we call a forum for the exercise of First Amendment rights. The state said they had a First Amendment right, but not at the governor's mansion, and we said that they did.
See, you were one of the defendants in this trial. What did you tell the jury about why you were on the property of the Blaine House and what you were doing there?
Okay. Now, why I was there is I really believe in the Occupy movement. Before I even found out about the movement, I knew something was wrong with our country, and I just could never put my finger on what the problems were. And once I found out by accident, by watching a TV show, just by accident, I found out that Occupy Wall Street was happening. And I literally jumped off the couch and went to my computer and started researching on it. And I found out that Occupy Portland started. I went down there for a few weeks. And then I found out Occupy Augusta started, went there. But I live in Wiscasset and my hometown is Brunswick, so then I started going to Occupy Brunswick. Why I was in Augusta that day was I had been going to some of their rallies the previous Saturdays. I made a personal commitment that I would attend a rally once a week because I couldn't stay in a tent overnight. So that's why I was here to support Occupy Augusta, because I felt like it was that important to keep that camp there in the park because they were standing up for us. And I wanted to show my support for them.
Did you believe that you were in the wrong? Or did you believe you had a right or a privilege to go onto the governor's grounds in protest?
Right. I definitely felt like I had a right to take it to the governor's mansion. I was nervous. I'd never been arrested before. But I felt like I was doing the right thing and it was my time to stand up.
Did you go there knowing or wanting to be arrested?
No, I didn't go there wanting to be arrested. I knew there was a chance I would get arrested. And basically that's all I knew. I wanted to make a stand. That's what I wanted to do.
What did you think about the mistrial? Were you surprised at all that 4 of the jurors obviously must have felt strongly about the Constitution and First Amendment rights, or what were your thoughts?
Right, right. I was really surprised when they asked to see a copy of the Constitution or the Bill of Rights, and I said, "Whoa, their thinking's going in the right way. They're not looking strictly at the law and the way the law was written." And to me, that was very encouraging.
Do you think this was a victory in a sense?
Yes, I do.
Are you worried about being retried, or?
I'm worried, yes, but I don't think it'll happen.
We're outside of the Kennebec County Courthouse with one of the defendants, David Page. David, what did you think about the outcome of this particular trial? Was it a victory in some sense?
I think it's a full-blown victory. Yes, sir. Yeah.
And why?
Yeah. Well, it's a victory because it's a victory for free speech. It's a victory for the Occupy movement. It's a victory for us.
So,
Yeah.
tell me what you told the jury when your attorney, Phillip Worden, said, "Tell the jury in your own words why you were there and what you thought you were doing." What did you tell them?
Yeah, I told the jury that I believed that I had a constitutional right to express my free speech on the Blaine House lawn.
Yeah.
That's what I told them. Yep.
So civil disobedience was part of what motivated you.
Yes. And
Yeah.
occupying the courts is part of what's motivated me.
Tell me a little bit about what do you mean by that?
Well, we've spent a long time here in this building, you know.
A day and a half, plus
Plus,
Jury
you know,
jury,
plus jury deliberations and the whole setup. It's a good foundation for further arrests in the state
yeah,
and around the country.
yeah.
Yeah,
So
that
what?
it is fightable, it is beatable, and
Yeah.
and the more time we spend in court, the more time we're occupying.
Supposedly, or from what we heard, there were 4 jurors who took the position. Well, we think they asked to see the Constitution or the First Amendment.
Which was denied, yes.
And why do you think they might have wanted to see that? And did they stake their claim on that?
I think it's clear that they did stake their claim on that.
Yeah.
Why they wanted to see that was, I can't speculate. I don't know, but
8-4 is pretty
8
significant.
to 4 is significant. Yeah,
Yeah,
it's a big
yeah.
deal.
Jenny Gray is also one of the 5 defendants in this criminal trespass case that just ended with a hung jury. Jenny, what are your thoughts on how this trial ended, a hung jury, and what did that mean to you?
On the one hand, I'm pleased that we didn't have to pay a big fine or go to jail, or I'm glad that even though they didn't find us not guilty, at least they had trouble making up their minds about whether we were guilty or not, because it was an indication of their thinking about our rights to free speech.
That are guaranteed in the First Amendment of the Constitution.
I think that's what hung them up.
Yeah, and there were 4 of them, obviously, because it was 8-4. Your attorney, when you were asked to testify and get up there in front of the jury, asked you to tell the jury in your own words why you were on the Blaine House property and what you were doing there.
Right. I think basically what I wanted to communicate was that the authority of the people to run their government had been usurped by people with a lot of money on Wall Street. I told them that I stood firmly for what Wall Street was, Occupy Wall Street was standing for, and that the situation was dire enough that I wanted to make sure that we could get power back to the people.
And did you go there with the intention of being arrested?
I knew that there was a 50-50 chance that I would be, but I was so outraged at the time that they had silenced the voice of the people finally getting together and trying to figure out what was going wrong with our government, and we were just getting off the ground and becoming a place where the public could come for information and to figure things out. And for that voice to be silenced, I was angry enough that I wanted to make a public statement, and that was the best way I thought that we could.
What's the significance of this trial ending this way?
Well, it gives me hope that there are a portion of the population of my peers that is aware and concerned with what's going on with corruption in our government and are questioning authority. And I think it's reflected in they stood firm on not caving into whatever peer pressure there is in the jury room to not go with the given order and the authority now in power.
I'm here with Kim Cormier, one of the 5 defendants in the criminal trespass trial. Kim, first of all, what do you think the significance of this hung jury mistrial is?
I just think that more people support us than are letting on.
Yeah,
Really.
so you think there were 4 people, from what we're told, who wanted to see the Constitution, and the way you would describe them is you feel that they're people that are listening and paying attention, and finally were on a jury and were somewhat sympathetic. Do you think that was hard for them to do?
Oh, absolutely. I think it was very hard because they've got 8 people against him trying to bully him into making a decision that they didn't feel comfortable making.
Your attorney asked you, as part of your testimony, to look right at the jury and to tell them, in your own words, why you were on the Blaine house property and what you had hoped to accomplish. What did you tell them?
Well, basically that after the Wall Street bailout, several people walked away from that laughing all the way to the bank, but it's becoming very fashionable for the government to point the finger at poor people as the problems in this country. That they're someone getting a little bit of food stamps or something like that is going to be breaking the government, and I don't think that's the case at all. I think the problems run much deeper than that. And
So you were there to protest that.
yeah,
And were you there to protest the fact that the camp was going to be, they were going to be evicted?
no, I didn't even know about it.
You didn't know about
No.
it. So yours
I
was
didn't.
just about what's happened to our country, the bailout, and you wanted to take that grievance where?
Yes, to a public forum, actually, just to put it so we could actually be seen and heard. Because, petitioning our legislators isn't going to do a thing, really, at this point in time. I don't think it accomplishes anything. They're doing legislation right now that's just taking away our rights left and right, really. So,
Yeah.
What good is it going to do for us to write a letter to our representative, which they're not representing us?
So you felt this was what, the best statement you could make?
Absolutely, absolutely. I think everyone should be doing it. I would do it again in a second. I think that it's necessary.
So how do you feel about the hung jury and where it may go from here?
I'm thrilled. If we have to go to court again, we'll see what happens. But I think that sends a very powerful message.
Are you going to be as nervous?
Yes, absolutely.